Hey everyone, in today's video, we are going to talk about directors' duties to the companies under common law. In the previous video, I discussed directors' duties under the Companies Act. Companies Act is statutory, that means laws passed by Parliament. Common law is judge-made law, that means laws made by judges that are passed down over the centuries. So today we are going to talk about the common law duty of directors to act in the best interest of the company. Directors have to exercise their discretions, make their decisions relating to the company bona fide, that means genuinely in what they consider to be in the best interests of the company. The courts are concerned about whether the directors have acted honestly in what the directors considered to be in the company's best interest. The courts are not going to be, I'm not going to substitute the judge's opinion of whether they acted properly or not. The courts are considered about whether the directors have acted honestly in what the directors have considered to be in the company's best interest. So when the acts of the directors are challenged, the courts do not substitute their own judgment for that of the directors. In other words, as long as the directors have acted honestly, the judges are not going to second guess the decisions. They are not going to substitute the judge's own view of what the directors have done. Let me give you an example of the case of W and M Roth Limited. In this English case, the director, Mr. Roth, entered into a service contract with his company, providing for a pension for the wife. The wife was not really employed by the company, it was just an agreement. Under this service contract, the pension was to be given by the company to the wife in the event of the death of the director, Mr. Roth, without taking into account whether the contract was for the benefit of the company. The courts found that the whole purpose of the contract was to benefit Mrs. Roth, the director's wife, and not to benefit the company. It was to provide for her pension. Therefore, they found that the contract was invalid because the director, Mr. Roth, did not act in the best interest of the company. In fact, Mr. Roth was acting in the best interest of his own wife. In other words, Mr. Roth breached his fiduciary duty to the company to act in its best interest, and the court held that the contract for the provision of the pension was void. Next case I'm going to talk about, Walker and Wilburn. That's an Australian case. The liquidator brought a lawsuit against the directors of a company called Asiatique for causing Asiatique to pay money to other companies in a group, although during the court proceedings there was no evidence that the companies in the group were related in any way. So the directors of this company called Asiatique made loans to other companies within the group without any security and without any interest repayments. And there was no consideration for the repayment. In other words, there was no quid pro quo. You can watch the video I did below on consideration. The directors of Asiatique also used the Asiatique's money to pay the employees' salaries of other companies within the group. So the Australian High Court held that the payments were in breach of the directors' duties. The Australian High Court held that it was the duty of the directors of Asiatique to consult its interests and its interests alone in deciding whether the payment should have been made to the other companies. In Singapore, Section 159 of the Companies Act provides that in exercising their powers, directors are entitled to have regard to the interests of the company's employees as well as the interests of its shareholders. In the case of Peter's American Delicacy Co. and Heath, the court held that the directors may have regard to the interests of its shareholders. Because the position at common law, the directors may have regard to the interests of its shareholders, because the position at common law is that since shareholders collectively as a group do in a sense comprise the company, notwithstanding the company's separate legal personality, therefore directors can have regard to the interests of shareholders as well. The entitlement to have regard to the interests of employees is also a sensible one, since advancing the interests of employees will often be in the best interest of the company. Directors do not have to take into account the interests of creditors when making corporate decisions. But when a company is unable to pay its debts, that means it is insolvent, the interests of creditors must be taken into account. This is because the creditors of an insolvent company, that means a bankrupt company, are entitled to appoint a liquidator to get into the assets of the company to which the creditors have a prior claim before the shareholders of the company. Shareholders rank last during the bankruptcy of a company. Therefore, in such circumstances where a company is insolvent, directors must ensure that the affairs of the company are properly administered and that the property of the company is not dissipated or exploited to the prejudice of the creditors. So thanks for watching this second video on directors' duties at common law.